Thank you, everyone, for joining us for today's webinar, Celebrating the Best in LGBTQ Legal Scholarship, presenting the 2025 Duke Minier Awards winners. We now turn to our staff attorney, Will Tintindo, for opening remarks. Will?
Thank you so much, Kim, for that introduction. Good afternoon, everyone, and welcome to today's webinar, Celebrating the Best in LGBTQ Legal Scholarship, presenting the 2025 Duke Minier Awards winners. My name is Will Tintindo, and I'm a staff attorney at the Williams Institute, and I also serve as the Williams Institute's advisor for the Duke Minier Awards Journal. I will be kicking off today's symposium with some short opening remarks about our journal before handing it over to our moderator. Before we begin, I'd like to thank the students of the Duke Minier Awards Journal, and in particular, former editor-in-chief Jet Harbeck, for all of their work on volume 24 of the journal, and for organizing this event, as well as the Williams Institute's communications and events team. I'd also like to thank UCLA Law's Outlaw and Queer and Trans People of Color Collective for co-sponsoring today's event. Each year, the Duke Minier Awards Journal acknowledges the best law review articles written by professors concerning sexual orientation and gender identity. Our journal republishes the 4 Duke Minier Award-winning articles originally published during the prior academic year, alongside the winner of the Jeffrey S. Haber Prize for Student Scholarship. The Haber Prize recognizes the best law review note written by a student in the field of sexual orientation and gender identity law. I am honored today to introduce the speakers for our event, the winners of the 2025 Duke Minier Prizes, starting with the professors acknowledged for their articles from the 2023 to 24 academic year, Noah Benasher, Margot J. Pollins, Dee Dangaran, Dara E. Purvis, and Ari Ezra Waldman. We will also be hearing from the winner of the 2024 Haber Prize for Student Scholarship, Gabriel L. Klappholz. Altogether, the 5 articles by this year's Duke Minier Award winners were published this August in volume 24 of the Duke Minier Awards Journal. This most recent volume, in addition to other past volumes, are available for free access on the Williams Institute's website. And as a reminder, our 2025 student writing competition is open right now, and the deadline to submit an article for consideration is Monday, December 22nd. If you are a current student, we encourage you to submit your work, and more information can also be found on the Williams Institute's website. And finally, this webinar does offer CLE credit for California attorneys. As a reminder, in order to receive CLE credit, you must attend the full webinar, and the materials for today's webinar are available on the Williams Institute's website as well. Without further ado, I'd like to introduce our moderator for today's event, Shane Ball. Shane is a current 3L at UCLA School of Law and the editor-in-chief of the Duke Minier Awards Journal. Shane.
Thank you so much, Will. Good afternoon, everyone. Thank you so much for joining us. Today, I have the honor of introducing each speaker before they begin their remarks. There is a Q&A feature available in our Zoom, but there's not going to be a designated amount of time for each speaker to answer questions. So we'll take questions if we have the time in each time slot. We do have to keep things moving. We have a full agenda today. So without any further delay, I'd like to introduce our first speaker, who is an assistant professor of law at the University of Hawaii at Manoa Richardson School of Law, Professor Dee Dangaran. Professor Dangaran's article, Bending Gender, Disability Justice, Abolitionist Queer Theory, and ADA Claims for Gender Dysphoria, was awarded the Stu Walter Prize, and it was originally published in volume 137 of the Harvard Law Review Forum. Welcome, Professor Dangaran.
Thank you, Shane, and thank you to the student editors of the Duke Minier Awards Journal and the staff at the Williams Institute for recognizing my work. It is so good to be part of this amazing volume alongside colleagues whom I admire and to be speaking here today among family and friends. I think it would be the understatement of the day to point out that much has changed in the year and a half since my essay was published. I want to situate my piece in the present because I believe the disability law claim for gender dysphoria that I'm defending in this piece offers an avenue forward for challenges to gender-affirming care bans now that the Supreme Court has held in United States versus Scrimetti that such bans do not violate the Equal Protection Clause. The history of civil rights in this country is defined by movements demanding more protections, liberties, and rights when the Constitution falls short. In the disability context, the Supreme Court applied rational basis review to the claim in City of Cleburne versus Cleburne Living Center. Although the plaintiffs there prevailed under the test, activists mobilized and pushed Congress to pass the Americans with Disabilities Act in 1990, providing a statutory right that set a much higher bar for public and private entities to meet when a plaintiff raised a disability law claim against them. When the court started to deny plaintiffs relief at the threshold question whether they qualified as having a disability as defined by the statute, Congress responded with the ADA Amendments Act of 2008, underscoring the breadth of the definition. I give this context because while there is always more work to be done, the disability rights movement undoubtedly achieved significant success in reshaping the United States to be more accessible to all. But there was a catch. Because of the last-minute, animus-driven work of Senators Jesse Helm and William Armstrong, the ADA, as passed in 1990, explicitly excluded, quote, transsexualism and, quote, gender identity disorders not resulting from physical impairments from coverage. And Congress did not remove that exclusion in 2008 when it amended the ADA. So one question is, how can the disability justice movement combat this exclusion? Professor Kevin Barry at Quinnipiac Law School and Jennifer Levi at GLAD have architected a legal challenge after transsexualism and gender identity disorder were removed from the DSM and the diagnosis gender dysphoria entered it in 2013 when the DSM-5 was passed. Levi and Professor Barry were both involved in a case called Blatt versus Cabela's Retail Inc. That case is the first case to successfully persuade a federal court that gender dysphoria was not excluded from the ADA because gender dysphoria is not the same as a gender identity disorder. That case was in the employment context, though it quickly extended into the prison context, where most of the cases decided today have arisen. Enter the Fourth Circuit's decision in Williams versus Kincaid, the only circuit-level case to reach the question whether disability law covers gender dysphoria. The court found for the plaintiff, holding gender dysphoria is not excluded. At the time I wrote my essay, I was a movement lawyering and litigation fellow at Rights Behind Bars, actively litigating an Americans with Disabilities Act claim on behalf of a trans woman incarcerated in Georgia. I primarily viewed disability and LGBTQ rights scholars and lawyers as my audience. So this really is a piece by a movement lawyer, by a movement lawyer, for movement lawyers. In my essay, I did not want to get mired in defending the viability of the claim. Rather, I was interested in exploring the normative question whether lawyers should bring the claim now that it was gaining traction. So I presumed the claim was viable and then made 4 moves to show why lawyers should bring it. First, I present some qualitative results from a survey I conducted with grassroots organizers at Black and Pink Massachusetts, with whom I worked closely during my fellowship year. We included 3 questions about the ADA claim in a survey mailed to their inside members. My essay presented the outcomes of those 3 questions. The 37 transgender respondents, which represented a significant portion of the trans population in Massachusetts prisons, overwhelmingly supported bringing the claim, even if it would stigmatize them. These results are clearly informative for those litigating in Massachusetts, but I am not trying to extrapolate those results to the entire country. I think that it can and should be replicated in different states if movement lawyers and activists are interested in thinking about this claim in their contexts. The upshot is that lawyers should ask their clients who are trans and/or have gender dysphoria whether they want to bring an ADA claim. If a plaintiff does not want to pursue it, then of course they don't have to, and their lawyer shouldn't. But the lawyers should not be making that choice for them, particularly when it can be more successful than alternative claims under the 8th Amendment. Second, I do a deep dive into various versions of the DSM, DSM-3, DSM-4, DSM-5, in what I call an autoethnographic analysis to show that gender dysphoria truly is distinct from the previous identity-based diagnoses. I conducted a close textual analysis of the DSM, which should inform a textual analysis of the ADA, while including vignettes of my emotional and intellectual responses to the ways that the American Psychiatric Association has viewed the trans experience of dysphoria over time. I share my positionality in this section, though that has changed today. Specifically, I stated that I did not receive a gender dysphoria diagnosis by time of publication, but now I have, and I've utilized various forms of hormone therapy as part of my gender-affirming care, which is just to say that anything spoken about trans rights is always changing because trans people are changing. So this piece is already outdated, even on that autoethnographic front, though the visceral reactions are still how I feel about the outdated diagnoses. Third, I discuss the disability justice movement and the future we are all linked in either working towards or heading towards in our lifetimes. I argue that gender dysphoria has a place in that disability justice future, situating my work amongst disability justice theorists. Finally, I engage in a heartfelt discussion of the counter-arguments to pursuing this claim. In dialogue with one of my dear friends, A.D. Lewis, who I'm not sure if A.D. is here today, A.D. litigates on behalf of incarcerated trans people. I asked him if he would be interested in writing a response to the essay, and we jointly asked the editors of the Harvard Law Review if they would publish it, and they did, so you can see A.D.'s response online. Though I was responding directly to what AD shared at a Lavender Law panel about this claim, I connected his arguments regarding medical gatekeeping, self-identification, informed consent, and soft policing to writing from law professors and organizers that have raised similar critiques. I think AD's points emphasized that claims hinged upon gender dysphoria diagnoses do not support the autonomy of trans people, as other options may. My normative argument boils down to the fact that I view all litigation as a form of harm reduction, not the vehicle for true abolition or transformative justice. In an earlier work called Abolitionist Lodestar, I adapted the abolitionist concept of, quote, non-reformist reforms to create an abolitionist spectrum of interventions that lawyers can make on behalf of incarcerated trans people. First, carceral interventions can be thought of as reformist reforms, in that they rely on or prop up the carceral state. So transferring trans women to women's prisons or creating an all-trans or all-LGBTQ unit, for example, are examples of carceral reforms. That's not to say that such reforms can never reduce harm. Rather, they do not necessarily get us closer to ending the need for prisons and actually may make it more challenging to do so. Next, non-carceral interventions are those that ignore the bars, treating people inside them as you would treat anyone else. By comparison, decarceral interventions are those that actively seek to remove people from the state of incarceration. So I put gender-affirming care litigation on the spectrum as a form of non-carceral interventions with the possibility, as Jennifer Levi has raised to me, of becoming decarceral, because states so badly do not want to provide this form of care that they would rather release a person to moot their injunctive relief than actually give them a gender-affirming surgery or various forms of care they may be pursuing. So as pragmatists, using this always already compromised tool of litigation to support those who face torturous conditions on a daily basis, I believe we should be bringing to bear every tool possible. I think I don't want to run out of time for question and answer, so I'm going to stop there and just end with a quote actually from Audre Lorde, from her often quoted speech in 1979, which has been one of my guiding lights in this project and others. Those of us who stand outside the circle of this society's definition of acceptable women, those of us who have been forged in the crucibles of difference, those of us who are poor, who are lesbians, who are Black, who are older, know that survival is not an academic skill. It is learning how to stand alone, unpopular and sometimes reviled, and how to make common cause with those others identified as outside the structures in order to define and seek a world in which we can all flourish. It is learning how to take our differences and make them strengths. For the master's tools will never dismantle the master's house. They may allow us temporarily to beat him at his own game, but they will never enable us to bring about genuine change. And this fact is only threatening to those women who still define the master's house as their only source of support. I hope you all join me in the long-term work of finding other sources of support as we beat the master at his own game. Thank you.
Thank you so much, Professor. We've got one question in the chat here. So a lot of your work is focusing on how the ADA could be a really helpful vehicle for people who are in prison and are trans. But do you think there's any other subpopulations of trans people that this could be a viable or particularly helpful claim for? Or is there really kind of is the special advantage really just for people who are incarcerated?
Great question. So I think no subpopulations. I think this benefits all trans people who have gender dysphoria and those who may want to pursue a gender dysphoria diagnosis, but for whatever reason are being barred from doing so. So in light of these gender affirming care bans that exist both behind bars and in the free world or in the world that we are all in, if we're on this call, I do think that now that Scrimetti has said that a ban is focused on medical use, not on sex, the challenge is saying that this actually is disability discrimination, not simply a ban on a specific type of medical use, such that if someone has gender dysphoria that is disabling, preventing them from accessing medical services simply because they have that diagnosis is discrimination. So I believe this can be brought in response to state legislation, in response to employment behavior, as the first case in Black versus Cabela's was. This is definitely a claim that we should all be thinking about in all of our contexts.
That's great. Thank you so much for your great presentation, your interesting work. Our next speaker is a professor of law at UC Irvine School of Law, and that's Professor Ari Esma Waldman. Professor Waldman's article is called Gender Data in the Automated Administrative State, and it was awarded the Ezekiel Weber Prize. And Gender Data was originally published in Columbia Law Reviews, Volume 123. So Professor Waldman, take it away.
Great, thanks, Shane, and congratulations to all of my co-winners, especially our junior scholars who have clearly found their extraordinary scholarly voice long before I did in my career. It took me a while longer, so I'm really impressed with all of the papers here and honored to be in this category and honored with them. I think a lot of these projects, even if they were written before the current moment, are still highly relevant, if not more relevant today, given attacks on trans and non-binary and other gender non-conforming populations. So what I'm going to do for just a few minutes is talk a little bit about this particular paper, and then I'll talk a little bit about its particular relevance for the moment now, even though I wrote it a couple of years ago. So I'm a scholar of information, of how information is socially constructed in part by society, but also by law. And this project was about how the state uses gender information inside its automated systems. So for better or for worse, many state practices are now automated. We use algorithms to determine what Medicare, Medicaid services people are going to get, all the way through to what tax returns are going to be audited. Algorithms mete out benefits to people and make decisions and predictions about individuals. And all of these systems work on training data. They work on information collected, not just directly from individuals like you and I, but bought from data brokers and collected passively from people's experiences online, both on private companies that share information with the government, also with the government directly. So how do automated systems that the government uses use gender information? And what, if anything, does the construction of gender data by those automated systems and by the state do to gender information? And what I mean by construct is that information about people's gender, sexual orientation, really anything, race, it is socially constructed by the means through which we deliver or means for which we share that information. In the gender context, for example, that means that if a state law says that in order to get a license in a particular state, you have to share all this demographic information, including sex, right? The law doesn't say how the state should go about collecting that data. So a real person, a human, has to develop a form or develop a process for how to collect that information. And a lot of times those forms look very different than how legislatures might have imagined, or they look like it, but they reflect the individual's work, individual's intuition, or information about how we should collect information. So there is a wide variety of practices that different states and different departments use to collect gender information. And this paper, as well as several other projects, were the result of a large scale scraping of tens of thousands of forms from labor departments, commerce departments, health departments, and other departments that collected gender information, or that have some type of what I call a gender box, a pairing of a question about gender with a set of answers. And that's how the state constructs what gender is. You can only answer a question about what your gender is based on the questions that are given and the possible answers. And only sometimes, and in fact, quite rarely, do those state forms have an open-ended box for you to say, for you to designate yourself, affirm your gender. Oftentimes, it is you're either answering a question about sex and you only have M or F as options. But even, and part of the contribution of this paper, even in situations, particularly in progressive states like in California, like in Massachusetts and elsewhere, but even in states that you might not expect, North Dakota Health Department, for example, that has what some might call a very inclusive gender box, where they ask for your gender and they ask if you're trans, or they have a two-step question. They have very inclusive answer options. That information, regardless of how inclusive or how trans or gender nonconforming inclusive the answer options may be, is binarized by the processes that the state engages in when it collects, shares, and ultimately uses that information in algorithmic systems. And the way that works is quite simple. When it's collected, the information is mostly subject to people's intuition, the intuition of frontline workers who are building these forms. Not always malice, sometimes it's malice, of course, but not oftentimes. It's mostly people who don't conceptualize or don't think that they need to collect any other information about gender more than M or F. And then there are sometimes people who aggressively want to collect more information because they see the collection of more granular data on gender nonconforming individuals as a way to protect against gender identity discrimination. So there are differences in approaches, but those differences in approaches in each context have an effect on what the question and answer options look like. But then that information is shared. They're shared between agencies within the state. They're shared between states. They're shared with the federal government. They're shared with private entities. And oftentimes, that information is shared through agreements between state agencies that also don't specify how that information is going to be collected or how that information is going to be shared. And this gives another opportunity for that information to be binarized, because most of the time, the information that is shared in a way where frontline workers or the law will say, well, we need to simplify this data. We need it to be useful to people. We need it for people who are going to understand what this information is. So a commitment to efficiency and a commitment to simplify data and a commitment to what computer scientists call interoperability means that the information, regardless of how it's collected, ends up being shared mostly in a binary way. And then finally, upon its use in software systems and other algorithmic models that are used to make predictions about people, these models are built by engineers who have no idea what gender is, who have no idea about gender nonconformance, and their prime directive is to make efficient algorithms to reduce costs for government services. And the most efficient algorithms are the algorithms that can operate on ones and zeros, like on or off, true or false, binary options, therefore male and female. There are, of course, many different exceptions, but the point of what my research shows is that over the process of the social construction of data, through the collection stage, through the sharing stage, and through the use stage, these processes inside the law will binarize the data increasingly so as the process goes on. And of course, this has implications. This has implications not only for trans populations, but also for how our administrative state functions. And certainly if there are questions, we can talk about that. But I'd like to conclude by saying that this research, and I have to admit, I think even the research of my colleagues here who are sharing this award or additionally awarded is even more relevant now, because when I look at a lot of these forms that I scraped several years ago, many of them look different. And this is going to be a future project of mine. There has been a direct assault on what some would see as more inclusive data collection, gender data collection methods, to either just go back to sex MF and have that be the only gender the format of collection. Oddly enough, there are people who argue, you might not expect, although for some of us this is quite intuitive, you might expect that that would be a bad thing, that everyone who wants to be seen, like we should have gender nonconforming people seen in these surveys and have their voice represented. But maybe it's better for the state to get out of the business of gender data collection entirely, because much of that data can be used, and the more granular that data becomes, the easier it might be for the state to surveil populations who are vulnerable to state harm. So it's worth it to think about gender data, not just for its processes and how it's socially constructed, but what would better gender data collection look like? Would it be more inclusive, meaning more options? Or do you think, as many of us think, not all, of course, that it might be better for the state to not collect gender data because sometimes it's better for the state not to know, especially the state that we're dealing with now. I want to congratulate again all of my co-awardees and thank you again to the Williams Institute. I'm happy to answer any questions.
Thank you so much, Professor. So it looks like we have one question here in the Q&A. Someone's asking about all of the recent kind of attacks and malfeasance on federal data coming from Elon Musk and the Doge operation in the spring. Has this had any sort of disproportionate impact on gender nonconforming people? Are there particular risks there that you've seen or that you would hypothesize?
Yeah, there are always going to be disproportionate risks borne by the most marginalized populations. And in this particular case, so for those who may not be aware, we don't even have all the information, but a lot of us, we know that Doge was given access to pretty much information on everyone and hundreds of millions of Americans, and personal information, financial information, health information, and there's definitely gender information in there. We don't know exactly what they have. But the reason why this information, we don't know what it's going to be used for. We know that this information has been shared with arms of the federal government for immigration purposes, but we also know, so there's certain disparate harm in that vein. But we know that states are also going after not just trans individuals, but families with trans kids who are supporting their trans kids by getting them gender affirming care. Already in Texas and in other states, they're considering this child abuse. So the more information about who is trans or who is non-binary and who is doing what with medical care, all of which may be accessible through algorithmic processes in the information that in the raw data that they have, if not directly available, is going to enhance the state's ability to surveil and challenge and go after what they think is, bad policies. And what this administration thinks is bad policies, of course, is anything related to trans and non-binary rights.
Thank you for a sobering but insightful assessment. And thanks so much for your presentation. We're going to move on to our next prize winners, Professor Noah Ben Asher and Professor Marco Pollins. Professor Ben Asher is Professor of Law at St. John's University School of Law, and Professor Pollins is Professor of Law at the Elizabeth Hobbs School of Law at Pace University. Their article is called Gender Regret: Spanning Abortion and Gender Affirming Care. It was originally published in the 2024 volume of the Utah Law Review, and it has been awarded the Michael Cunningham Prize. So welcome both.
Thank you so much. Thank you, Shane, to all of the students of the Duke Mini Journal and staff at the Williams Institute. This is such an honor, and especially a joy for Noah and me to receive this award together as a celebration of our career family. So I'm going to talk a bit about the project, and then Noah will pick it up on any questions. Although I should just add, I'm coming to you from a table inside of the Detroit airport. So if there's any interruption here, Noah will jump in. Okay, so our project is about the use of regret in several different contexts. So conservative lawmakers have deployed regret as a powerful weapon, both in campaigns against reproductive rights and in campaigns against transgender rights. Across 23 states that have banned transgender healthcare for minors, states restricting abortion access, we see the same strategic argument in both legislation and judicial decisions. Sorry, everyone is telling me I'm a bit echoey. I wonder if I should turn it over to, let me just switch.
Microphone.
I can pick it up.
Is that better?
Oh, that's much better. Go ahead.
Okay. So across gender restrictions on gender affirming care and abortion, we see the same strategic argument that states must protect people from medical decisions that they might later regret. But here's what the data actually shows. Regret rates for transgender healthcare and for abortion are actually quite low. While regret rates for having children, that is the decision to become parents, are significantly higher. Yet there is no comparable legislative campaign to ban parenthood. So there's something deeper about the regret narrative as it appears in the trans healthcare context and in abortion. These campaigns operate through two key legal mechanisms. First, they establish regret prevention as a legitimate state interest. In the Supreme Court's 2007 decision in Gonzalez versus Carhart, Justice Kennedy confirmed that the state could ban certain procedures to protect women from decisions they might later regret, despite acknowledging that there was no reliable evidence for this concern. The Supreme Court's recent decision in U.S. versus Skermeti extended this logic to transgender healthcare, upholding Tennessee's ban on transgender healthcare for minors based partly on the state's findings about potential regret. The second legal move that we see is to transform regret itself into an actionable legal injury. And states have done that through bans on gender affirming care by creating unprecedented tort liability for medical providers. And these laws do that in a variety of ways. They extend statutes of limitations, sometimes by as much as 30 years. They eliminate consent as a defense, and they recognize the emotional harm alone as a sufficient injury to be the basis of a tort claim. They also establish negligence per se claims for statutory violations. The result, states can deem urgent and necessary forms of healthcare criminal, and doctors face decades of potential liability based solely on patient regret, fundamentally altering the practice of medicine. So what's really going on here? The strategic use of regret becomes clear when we examine the broader conservative agenda. This isn't about medical evidence. It's about enforcing what Pat Buchanan calls traditional family values in his 1992 culture war speech. What are the values at stake? They are natalism and the male-female binary. Both the anti-abortion and anti-trans healthcare campaigns center on promoting childbearing and traditional gender roles. Abortion bans force pregnancy and motherhood. Transgender healthcare bans consistently warn about fertility risks, even when fertility preservation is possible and increasingly practiced. The underlying message, cisgender reproductive lives are the preferred outcome. Next, the use of regret is designed to preserve, or in the case of intersex, produce a male-female binary. Transgender healthcare bans reveal deep anxiety about sex as mutable. They universally define sex strictly as biological sex at birth, excluding gender identity. They allow medical intervention for intersex children to maintain the binary while banning it for transgender youth who challenge the binary. This contradiction exposes the real goal of bans on trans healthcare. Surprisingly, this is not actually about preventing regret, it's about preventing transgender existence. A conservative legal agenda on these family values reveals a striking paradox in how regret narratives are deployed. The same lawmakers and advocacy groups that invoke regret to justify sweeping bans on transgender healthcare and abortion simultaneously ignore or silence other regret stories that don't serve their ideological agenda. How many people do you know who regret becoming parents? Probably more than have ever confessed it out loud. The selective deployment of regret narratives is telling. Some stories are amplified, others are silenced. Small numbers of people who discontinue transgender healthcare become poster children for bans. Post-abortion regret testimonies drive waiting periods, mandatory counseling, parental consent laws. Childless individuals are constantly warned they'll regret their choice. But at the same time, parents who regret having no children, who regret having children have no platform. Take a look around on the bus at morning rush hour. Intersex individuals who regret childhood surgeries have no legal recourse. Those who did not pursue transgender healthcare and now regret that choice are left out of public and legal discourse entirely. This pattern reveals that regret narratives are disciplinary tools, not genuinely concerns for well-being. So there are at least 3 critical problems with using regret to justify government action. First, regret is contextual and constructed. Data has shown that whether someone regrets transgender healthcare may depend more on social rejection or family support than on the medical intervention itself. Second, regret can be manufactured. Mandatory ultrasound laws, for example, can create attachments that generate regret. Post-abortion counseling services provide vocabulary for reframing complex emotions as regret. The regret these laws claim to prevent, they may actually create. And finally, regret conflates multiple experiences. Current laws treat regret as monolithic, but it encompasses trauma, disappointment, moral judgment, and simple preference changes. Each requires different responses. None necessarily justifies blanket bans. So what's really at stake? These regret-based restrictions on abortion and transgender healthcare for minors represent a strategic conservative movement using emotional appeals to advance ideological goals. When courts and legislatures accept regret prevention as legitimate state interest, they're not protecting vulnerable people, they're empowering government to override individual autonomy based on speculative future emotions. The real question is not whether some people might regret their reproductive or gender-related care. It's whether we'll allow the state to use the possibility of regret to control the most intimate aspects of our lives. The fight over regret is ultimately a fight for the right to make our own choices about our bodies, our identities, and our futures, even if we might later wish we had chosen differently. We should all be skeptical of ideologically driven regret stories. They are foot soldiers in the ongoing battle for the soul of America. The capacity to experience regret is fundamental to human freedom, not something from which the government should shield us. As transgender activist Andrea Longshu wrote, the negative passions, grief, self-loathing, shame, regret are as much a human right as universal healthcare or food. There are no good outcomes in transition. There are only people begging to be taken seriously. Thank you.
Thank you so much, Professor Pollins. We have one question here in the Q&A from an attendee asking what the best ways would be to kind of counteract a legal regret-based argument in court. Like what can we do? What tools are there available to kind of try to dismantle or disarm these arguments?
So I could take this one. So so far what litigators have been doing is just going to the statistics and showing the low rates of regret. On the other side, conservative think tanks have been finding running new studies and finding new numbers, and so trying to change the number from 1% to a little bit more. And so I actually I often advocate for giving the numbers, but also focusing on the narrative itself and revealing the narrative itself as ideologically driven and not to be taken that seriously, the narrative of regret.
Thank you. That's helpful. And then someone chatted me a question too here of what you point out in the article that the Northern District of Texas and the Fifth Circuit have granted standing on some of these regret-based injuries. Is this common in other federal courts, or is this just limited to ND Texas and the Fifth Circuit?
So I think it's the early days when we're talking about the bans have just been enacted over the last three years, some of them just this year. And so the kind of the medical malpractice cases, we're going to see them coming in later on. But in terms of the state, sort of the constitutional analysis and the state interest, those are showing up, and they played a role even in Scrimeti, where states are protecting, are defending their bans based on regret and talking about regret, and the judges are eating it up. They're loving it. The justices, the conservative justices. So on the torts front, I think it's to be determined. On the constitutional front, it's right here. This is the debate, and this is the discourse.
Great. And we have one more question here in the chat in our last minute. Someone asked, what are your thoughts about using regret-based injury claims in conversion therapy cases? So I guess this would be a private plaintiff having an action, I guess, in tort. That would be, I think that's what that person is going for.
Is just to clarify, is that raising regret as part of the injury in a suit against the conversion therapist?
That's, let's assume that, yes.
Okay, yeah. So I think that I would be sort of equal opportunity opposed to giving regret a sort of primary space in litigation across the board, right? For the reasons that we describe in the article, because of the ways that it is often something we come to feel later. It is so context driven and contingent that I think it could be problematic in that context in just the same kind of way that it's problematic in this context. And I would just say that in that context, the other kinds of more concrete harms that arise from conversion therapy are so powerful that you don't need to go to regret to have a strong claim there.
All right. Thank you. Oh. Okay, sorry. I think it's the Detroit airport noise. We will get, it's okay. We will get, that's I guess our torts intro. We'll get some more torts later with our last presentation, but thank you both so much. We really appreciate you being here. Our next professor is Professor Purvis, who is the James E. Beasley Professor of Law at the Temple University Beasley School of Law. And her article is called Transgender Students and the First Amendment, and it's going to be published in volume 104 of the Boston University Law Review. And Professor Purvis was awarded the M.V. Lee Badgett Prize. So welcome.
Thank you so much. I'm so honored to receive this award and to get a chance to be in conversation with all of my colleagues and students engaged in the same work. So I am interested in framing the rights of trans and non-binary students in public schools to express their gender identity through clothing, hairstyling, other elements of their appearance as a free speech right, and exploring what that means for legal analysis. I have been thinking about this concept for a few years now, so at other times, this has seemed like a perhaps abstract, interesting addition to a doctrinal quiver that at other times might have included the Equal Protection Clause and Title IX. But obviously today, with those paths basically cut off and increasing attacks specifically on the expression of LGBTQ plus people, I think this framing is even more important. So I will very quickly outline why appearance should be understood as speech, how that speech in schools would be evaluated under existing law, and finally propose what I think is a small tweak to that analysis that better acknowledges the role of schools in teaching students about gender and gender conformity. In thinking about appearance as speech, there is more of a case history around appearance as expression than you might expect. Not always sparked by trans students, but sparked by students who wanted to dress in a way that then dominant social norms saw as transgressive. Courts assessing free speech claims brought by these students did not universally find that they had speech rights in play, but the courts did say we recognize in theory that this could be speech, and the way that we know if it is speech is whether it has a recognizable message that the student can articulate and that other students and teachers would likely understand that message. In a variety of contexts, courts have already held that choices around clothing and appearance to communicate gender is a cognizable message that the listeners will understand. Courts have even reached to use trans people as an example of clothing choices as speech while rejecting claims of cisgender people. So framed as expression, the typical analysis of restrictions on student speech comes from Tinker v. Des Moines Independent Community School District, holding that school authorities may not prohibit or punish student speech unless the speech materially and substantially interferes with the school's educational activities. If a student's expression is so controversial that it distracts other students from their studies, then the school is justified in restricting that expression. But Tinker is not the only school speech case. There are a number of carve-outs away from Tinker that the Supreme Court has created in the years since that case that say here are contexts where you don't need to perform the disruption test at all. One such carve-out is from Bethel School District v. Frazier. A high school student gave a speech nominating another student for a position in student government with a lot of sexual innuendo. The nominating student was punished by the school. He challenged the punishment as violating his free speech rights, and he lost before the Supreme Court on the logic that his speech was vulgar, offensive, lewd, and indecent. So the sexualized speech that the student delivered, particularly because it was in an assembly where younger students were a captive audience for it, was seen as inherently harmful enough to be restricted. So many schools have tried to use Frazier in a variety of contexts rather than Tinker to justify restricting student speech, because then the school does not have the evidentiary burden of showing recent disruptions in the school. And this has been particularly important in the last few years as the right wing has reinvigorated stereotypes of LGBTQ plus people as hypersexualized. But a comprehensive evaluation of how lower courts have applied Frazier indicates that sexualized jokes, images, language are particularly likely to be found vulgar and lewd under Frazier. But not all sexualized expression is found to be lewd. There are plenty of gray areas around specific words. And if sexualized speech also has social and political value, that one came up in the context of a breast cancer awareness campaign with the slogan, I heart boobies. The Third Circuit said, even though this is a gray area of whether this language is lewd, we see that it has this additional value. The school cannot restrict it under Frazier. And even student speech talking about sexual behavior or sexual attraction has been held not to fall under Frazier if the speech itself was not sexualized. And crucially, no courts have held that merely discussing or referencing sexual orientation or gender identity is enough to characterize the speech as lewd. So I conclude that as much as there is a campaign to paint topics relating to gender identity as sexualized, that is not likely to succeed unless courts dramatically depart from past case law, which of course they would never do. As a result, restrictions on the expression of trans students will be evaluated under Tinker, which brings me to the doctrinal shift that I propose. In broader First Amendment analysis outside of the context of schools, the heckler's veto doctrine is the idea that the government shouldn't suppress speech due to the reaction of people who hear it, outside of narrow and extreme circumstances, such as inciting imminent lawless actions. The logic of Tinker runs counter to this principle, as under Tinker, the reaction of other students might itself be the material disruption to educational activities. And 3 appellate courts have acknowledged this doctrinal confusion, although none of them made a decision based on it. I argue that the speech of trans and non-binary students illuminates another dimension of this conflict between the heckler's veto doctrine and Tinker, in that the schools themselves deliver messaging and education about gender. namely that there are two sexes, and it is important and appropriate to organize people by sex. Sometimes this is explicit, as in sex education programs that traffic in stereotypes, sex-segregated bathrooms, sex-segregated sports teams. Sometimes it's implicit, such as gendered dress codes. Through all of the school's use of sex as an important division between students, the school helps to teach students that sex is binary, significant, and immutable. So I argue that reconciling the heckler's veto doctrine and Tinker means taking into account that the school has taught students what is strange enough to be distracted by. A student whose speech is restricted by their school as materially disruptive should be able to rebut the school's argument by showing that the school helped to create the disruption. The burden of proof should lie with the student to show that the school engaged in consistent and clear messaging that is in opposition to the student's speech before the student engaged in that speech. And not all of a school's messaging should shift the balance in favor of allowing disruptive student speech if the school's messaging is fact-based instruction that's part of the curriculum. If, however, the student can show that the disruption caused by their speech is effectively a heckler's veto stoked by the school, then the school should only restrict the student's speech where school officials had reasonable justification to forecast physically violent confrontations between students. And I'll use briefly some slightly tweaked facts from Holloman v. Harland, an 11th Circuit case, to illustrate this. In that case, a student stood with his fist in the air silently instead of reciting the Pledge of Allegiance with his classmates. And in the actual case, other students didn't have a significant reaction to his protest. But let's say that they did, that classmates confronted him and a resulting argument derailed the class. Under current Tinker analysis, the school would likely be justified in saying you can't continue this protest. Under my proposed shift, however, the student would be able to argue the school helped to create this disruption by engaging in consistent, clear messaging that patriotism is morally correct. And in the actual case, a state statute required that school districts spend at least 10 minutes per day developing traits, including patriotism, and as part of this, required that students recite the Pledge of Allegiance. This wasn't a fact-based part of the curriculum. It had an explicit normative goal of promoting patriotism. So the student would likely, therefore, likely be able to show that the school helped to create the disruption and his speech should be protected. Ironically enough, I believe that my proposal is now further bolstered by the Supreme Court's recent characterization of public school education as indoctrination in Mahmoud v. Taylor. I think my proposal accounts for the power of the school's messaging and better protects the speech of unpopular expression. It rejects recent attacks on the speech value of expression around gender identity and sexual orientation, which is particularly important in the context of speech by and around minors. And in a world of rapidly shifting legal ground that is specifically targeting transgender children, I think it provides an additional and potentially stronger source of doctrinal support for some of the people who most need our help. So thank you so much for your attention. Thank you to the Williams Institute and the Duke Minier Awards Journal for this honor.
Thank you so much, Professor. I think we'll take one question, and I think you may be able to, if you can see the Q&A too, this first question here, talking about citing an 11th Circuit decision regarding a trans teacher and asking how about the analog between teachers' rights and students' rights. So if you wanted to take that one.
Yes, so certainly as part of broader attacks on the First Amendment as a whole, teachers' speech is also being targeted, teachers' expression. And I mean, we have seen that in the last week, that a variety of expression by teachers is being used against them. So there have been a variety of cases in the 11th Circuit in New Jersey, where I live, and in a number of other jurisdictions around misgendering both teachers, students misgendering teachers, teachers misgendering students, et cetera. certainly what I am proposing does not necessarily speak directly to all of those, but what I'll address briefly is something I didn't have time in my full presentation for, which is there is a second prong of Tinker that specifically talks about speech that invades the right of other people. And so Tinker gets the most attention for the material disruption. But the Ninth Circuit and a couple other California courts have used this invading the rights of other prong to draw a line between sort of abstract speech that people might find offensive, which is the materially disruptive part of it, and speech that specifically attacks someone else. So I would characterize deliberate misgendering speech as falling under this second prong of Tinker, which would remain sort of unchanged by my proposal. So maybe the short version is I think Tinker actually still does work there, just not the part that I am focused on.
That's great. It's really insightful. Thanks so much. I'm very happy to introduce our final speaker for today, Gabe Clapholes, who is a current 3L at Yale Law School. As Will mentioned earlier, Gabe's article called Queer Outrage, Why the Legal Vindication of LGBTQ Feelings Can Transform Dignitary Tort Law was awarded the Jeffrey S. Haber Prize for Student Scholarship and was published in our journal. So welcome, Gabe, and take it away.
Hi, everyone. My name is Gabe. I just first want to thank the DAJ student editors. I'm an editor of much scholarship as well. And in my law school experience, I know how much work goes into it. So I really appreciate all the edits you've given me and the feedback. It's really made the piece so much stronger. I also want to thank Jeff Haber, who supported this award and who I met with earlier this year, and who we had a lovely conversation. I finally want to just thank the other scholars. It's really nice to be in community with people, especially during this time when it feels like we're fighting vigorous attacks on all fronts. I wish I could take a course with each of you on each of these subjects. Unfortunately, law school is only 3 years long. So moving into my paper, this emerged, I wrote this paper nearing 2 years ago as a 1L. So it's I think also I would have written it differently in light of what's changed in the country since then. But in any event, my paper focuses on the tort of outrage, also known as intentional infliction of emotional distress. And when I first learned about this tort, I read the restatement's odd and tautological characterization of the tort as recitation of the facts to an average member of the community that would lead them to exclaim outrageous, which of course does not define what outrageous conduct is. And so the way that this tort has developed is oftentimes through the way that the public would just consider, an average member of the public would consider certain conduct to be beyond the bounds of common decency. And the result of that is that a lot of tort scholars have characterized it, in the words of Paul Hayden, he said that one could scarcely imagine a tort more tied to ill-defined communitarian norms of conduct. And so it's often perceived as a highly majoritarian tort. My paper challenges this notion, looking at the history of how this tort has been used by LGBT plaintiffs. And what I found was this shocking, at least to me, a shocking history at the height of the AIDS crisis and long before the contemporary victories in the LGBT rights movement of Obergefell, Bostock. We see, huge quantities of plaintiffs succeeding in IIED claims, asserting their dignity in court. So to give some examples, a federal judge allowed a suit to proceed against a boss for making homophobic comments at work in the early 90s. A transgender man's mother prevailed in arguing that a police officer's invasive questioning of her son was outrageous. A lesbian woman prevailed against neighbors who circulated threatening letters. And it's this kind of interesting instance in which courts, which we would normally assume are pegging IIED to majoritarian notions, actually taking into account the LGBT identity of the people who are suing and incorporating the discriminatory nature of the speech against LGBT people who are named in these cases, as making these claims more persuasive. Because, of course, a slur used against a straight person is less injurious emotionally than a slur used against a queer person. And so taking all of this history, which I just found absolutely fascinating, and reading these cases, when AIDS deaths were at their absolute height, is to me really incredible. And I think it shows that IIED is not just a tort about the majority, it's also a tort that has historically recognized power imbalances, and that serves the minority interests that people are asserting in court. And so taking all of that, I went to look at how the IIED tort has operated today. And what we've seen in recent years is a major clash between IIED and the First Amendment in cases like Snyder v. Phelps, which was in 2009, where the Westboro Baptist Church was protesting at a funeral for a deceased veteran whose father was gay and who filed an IIED claim, which he lost based on what the court called the matters of public concern doctrine. And the idea here is that, for the First Amendment in these instances is so often read as kind of categorically victorious over the IIED claim when LGBT plaintiffs are bringing it. And so the First Amendment kind of really is the big question when it comes to IIED today. But I think that the history that I discovered gives some indication of how we can actually approach these cases with greater case-by-case specificity. If IIED is a tort that also really recognizes the identity of the people who are, alleging, the tort, it actually in many ways encapsulates and promotes other First Amendment interests, right? So the First Amendment, if we are actively promoting the most expression possible, would encourage more people to come to the expressive table. And so, an attack on an LGBT person through verbal assaults has a more deleterious impact on their First Amendment interests than on somebody else, right? Of course, this is not how the court currently approaches it. And so what my note proposes, drawing from the work of Professor Pollard Sachs, is to really look at ways in which the courts can develop a balancing test, looking at the First Amendment interests on both sides of these kinds of cases. Because part of the problem is that when the First Amendment is only on the side of the defendant in an IIED clash with the First Amendment, the queer identity of the plaintiff only gets factored in to heighten the power of the defendant's First Amendment claim, right? Because if, in the example of the Westboro Baptist Church, they were invoking queer slurs, and the court then said, okay, this is a matter of public concern whether queer people should serve in the military. And so that then entitled it to higher First Amendment power. But of course, if we're only factoring an LGBT identity to empower one side of the case, it's going to result in incongruous results. And so I argue that the history that I found in the 1990s and early 2000s that shows that IIED can actually serve minoritarian interests and protect the dignity of people coming into court should encourage the court to embrace a balancing test that is far more in line with an anti-subordination perspective of the First Amendment than what the current court does. So I'll conclude there and just say that I've really enjoyed this talk so much, and I'd be curious to hear if there are any questions. Thanks so much.
All right, thank you. Thanks for a nice private law paper to balance out what was a lot of public law earlier. Okay, so the first question here we've got, for those of you who don't know, tort law is common law and it's state law. So it's not, there are some federal tort laws, but it's most actions at a state level. So if different courts are in different states doing different things, do you think, Gabe, that there is going to be some sort of greater protection for tort plaintiffs who are LGBT suing in states that are more LGBT friendly generally? Like is a tort plaintiff who's trans in California versus Oklahoma going to have a different outcome on this tort?
I mean, it's definitely possible. And I think in my research, I did find a lot of that happening. I would say then, still, though, I think it's important that a lot of these cases, especially when it comes to the First Amendment, are constitutional and so do become relevant across the board in all of these tort suits. And so it's this moment where I think tort law kind of does become federalized in this way because you're dealing with the constitutional provision that gets then applied in a court case, Snyder v. Phelps, that gets applied across the board in every IIED suit, whether you're in Oklahoma or New York.
Great, thanks. That's super interesting. And so then we've got another question here, which is talking about how, right, your paper is there's this path to expanding tort liability, but also, right, this is against the backdrop of like the tort reform movement and critiques of tort and tort recovery. So how do you kind of balance, like, what do you think about kind of these two kind of, trends that are running against each other?
Yeah, I mean, the paper is certainly pro-tort, maybe in part because I wrote it during my first tort class. So that's a fair critique. And I think that, I mean, ultimately what I'm trying to do here, though, is develop a balancing test. It's not saying that LGBT plaintiffs in every case should win because they're LGBT. It's saying that there are particular identities that the courts are just not paying attention to at the Supreme Court level that courts for a long time have paid attention to. And that in actually taking those identities into account, you can reach a result that actually makes more sense with what IIED is and what it tries to do. So, I do think that there are a lot of these cases where the defendants are completely right. And, even in Snyder v. Phelps, that's a case where I don't know if the court should have come out the other way. I mean, the family was 1,000 feet away from the protesters. They didn't see the protesters' signs until they were on TV that night. And so there are good arguments on the other side in terms of fulfilling the elements of IIED. I just would argue that I think the court needs to be more critical when it incorporates identity into these cases.
Thank you so much. That's really interesting. And with that, I think we'll wrap up. Thanks so much for being our final presenter and for being here. And thank you to all of our speakers for joining us this afternoon or morning or evening, wherever you are in the United States. And then we just want to thank everyone again for being here on behalf of the Williams Institute, on behalf of our journal, the Duke Minier Awards Journal, and also on behalf of UCLA School of Law. We'd like to thank you, and I'm very happy to turn it over to the chief note editor of our journal, Ambika, who is going to pump our student note competition for you and tell you how to apply.
Hi, Shane. Thank you so much. My name's Ambika, and now that you've heard from our 2024 student note competition winners, we'd like to remind you that our 2025 student writing competition is open right now, and the deadline to submit an article for consideration will be Monday, December 22nd. If you're a current student, we encourage you to submit your work, and if you're a professor or know current law students, please encourage them to submit their work. You can find more information about applying on the Williams Institute's website. And Shane will also send the link to that in the chat for you to look over. So thank you very much to all of our 2025 Duke Minier Award winners for joining us today. We'd also like to thank the Williams Institute communications and event team members for handling the logistics of this event. And finally, thank you all for joining us here today. We hope to see you again at another Williams Institute event. Thank you and have a wonderful rest of your day.